Have the design considerations hearing session. I'll be leading the hearing session in the same way as I did with the policy hearing session. I shall start off each item on the agenda by directing a question at one of the parties. After the answer, I shall invite the other parties to comment in turn. Again, I will be adopting a brisk pace. I'll move on when I consider I have the information that I require. Don't feel obliged to comment if you're just repeating points you've already made, or it's better expressed in the written material before me. Again, for the Community Council, there may be occasions where I'll be directing a series of questions at the appellant or the council. Please don't feel left out, and I always come back to you before I move on. So, can we turn to item 2, the first bullet point, protection of main views, and if I could start with the appellant's team. In your opinion, are there any views that need to be protected?
Sir, thank you. Certainly over the course of the consideration of the planning application, responses in particular from Historic Environment Scotland clarified the importance of a particular view from the main entrance of the site from Muir Hall Road, a view which we looked at when we were on the site visit meeting.
And is that the only important view, in your opinion?
Certainly in terms of the site as a whole, and I suppose that the setting of the building, the area of open space to the immediate south of the hospital building itself was regarded as being a very important view in terms of the setting of the building, and in terms of wider view stepping back from that. It was the suggestion of the entrance view where the building was sort of framed by the main approach on entrance.
Council, any comments on that? Would you agree with that?
Would largely agree with that. The primary view that was is of some concern to Historic Environment Scotland and the council is from the main entrance. As you view down, what you're looking for is as much of an uninterrupted view of the principal elevation of the A-listed building.
Okay, we'll come on to look at development at the entrance in the next bullet point. Community Council, anything to add to? So moving on to that point then, what's the appellant's view? Do they feel that the scale of development indicated on the illustrative plans would have any impact on that important view?
Sir, from our perspective, the illustrative layout was obviously submitted to the council as exactly that. It was the expectation that detailed master planning proposals would come forward at a future stage of the process. Notwithstanding, I think it's fair to say that we do acknowledge the Historic Environment Scotland response of the 16th of April last year, which goes on to make reference to the potential for development within the western extent of housing zone B, shown on one of the application drawings, could potentially have the effect of having an impact on that view that they had mentioned. They go on then to recommend that the development in this area be drawn back to avoid blocking of the view of the front elevation of the A-listed building. And from our perspective, we're comfortable that that can be controlled by way of a planning condition, and that that then can still allow for the similar quantum of development to come forward across the rest of the site.
We'll come on to that in a minute, but do you see the need for this principal view to be defined spatially, to say development can't be in these particular areas?
I think certainly from our perspective, sir, we would be comfortable with that approach. I think the Historic Environment Scotland response is quite clear in suggesting that there are particular parts of Housing Zone B where development should be controlled, and I think we would support and accept an approach along those lines.
Council, any thoughts or comments on that?
I would largely agree with that. I think what might be needed, if there is to be a condition, is to find out a parameter of that view that needs to be protected.
And obviously there's nothing before me with such a view. Is that something the parties could agree on? Is that necessary? Let's start with the appellants.
Certainly, sir. I think our view would be that that's something that could be submitted prior to the commencement of any development. It could be expressly stated, I think, in a planning condition requiring then details to be submitted in that respect. I know we're not covering conditions today, but so.
Yeah, no, I don't feel constrained about slipping into conditions, because one of the purposes of this session was to frame our discussion on conditions. I'm just conscious that, and we'll come on to this, I'm sure, but when it comes to planning permission in principles, you can either rely on the future submission of details and resolve it through that, or you can actually set out in your planning permission in principle a specific constraint. So I suppose my question is that view so important that it's necessary to actually spatially define a view that should be protected, or are there better ways of dealing with that? Any thoughts for the appellant?
I think certainly from our perspective, there's not much disagreement between ourselves and the Council on the point. I think we would be comfortable that we could, by way of a future master planning exercise, have regard to the nature of the view given the Historic Environment Scotland response that we have had. I think Historic Environment Scotland highlight the fact that it is an important view. I think we're comfortable that, given the nature of the fairly extensive tree coverage in that part of the site, perhaps more so further to the east, that that's something that could be dealt with by way of an ultimate master plan to be approved by the planning authority, which is something that is referred to in the draft conditions. Certainly from our perspective, we don't feel that the view needs to be particularly defined on the ground at this stage until such a time as we know the nature of the development coming forward.
Thank you. Council, any thoughts on that?
We do obviously consider the view to be important, and would agree that it can be designed out. I'm trying to come up with a condition in my head, but it's been quite difficult to define what those parameters of distance and separation that would be required. But certainly I would agree that it can be designed out, and the conditions that are proposed by the council will certainly assist in that in the drafting of a detailed master plan and a detailed layout.
Okay, thank you. Community Council, any thoughts? Right, let's move on to the next bullet point. And I recall this was raised in one of the consultation responses, or perhaps it was by the council. For the appellant, did you accept that the car parking area shown near the entrance to the main building could have a detrimental impact on the setting of the listed building?
So from our perspective, it's probably quite helpful to observe that the area of car parking actually relates specifically to the main hospital building. So it's designed to provide additional car parking for the detailed application which relates to the refurbishment of that building. In terms of overall impacts, there were specific discussions with Historic Environment Scotland about the opportunity that there might be presented by the refurbishment of the main building to stop the ad hoc parking that was fairly evident when the main hospital building itself was in operation. You had instances of fairly extensive parking along the entire length of the access road around to the Burnham and Elco villas and chapel. So certainly our understanding was from Historic Environment Scotland's perspective that the provision of a discrete area of car parking would certainly be preferable, doing what we could to ultimately protect as much as possible the area of open land to the south of the building. And we're fairly confident that a design can be achieved that would be acceptable both to the Council and Historic Environment Scotland. And we would note that Historic Environment Scotland didn't object to that particular component of the scheme.
So in general terms, you don't accept that that car parking area shown in front of the main building is detrimental to the setting?
I think that's our position. Certainly the proposition we suggest would improve the current situation and the propensity for that parking on the main road without such an area of car parking, and we feel that it can be designed in such a way, potentially with grasscrete or similar, to be able to blend in a bit more with the existing landscape. I would make the point as well, as we noticed on the visit to the site, that as you come in from Muir Hall Road, there's a reasonably significant drop down towards the main building, which may allow the topography to offer some form of screening to the parking proposed.
For the Council, any thoughts or comments on that?
Yes, I think it's very much a case of the devil is in the detail. There is a potential issue of, as you arrive into the site and your primary view of an A-listed building could potentially be dominated by a multitude of cars. Our preference would be to look at relocating it for just slightly further north of the building, so as you enter the site you see the building first and then your car parking is just afterwards. That may be something that can be achievable through design.
Appellants want to come back on that? Potential solution is relocation?
I think certainly there may be scope to look at some minor amendments to the layout of that car parking. I think I'm mindful that that area of the site forms part of the detailed application for planning permission, so any changes would no doubt have to be covered as part of that proposal. But certainly I think there could be some amendments to the siting as proposed.
Community Council, any thoughts on this?
Yes, perhaps just to add a little bit of local knowledge as part of the considerations for car parking there. I don't have a view one way or the other, but just to be aware that with the current Murray Royal Hospital, which obviously a lies adjacent to the site. NHS Tayside have never successfully implemented the travel plan that was associated with the planning permission that those buildings were given. The upshot of that is that there are something in the region of between 30 to 50, and I'm not exaggerating, cars parked daily at the current Murray Royal Hospital site, which are out with their allocated parking spaces. They actually park in the access for fire engines and emergency services. That's never been successfully addressed. So just to be aware that there is a latent demand of car parking from the current hospital staff, that if the car parking in the proposed applications is not carefully cited, you will suddenly potentially find a lot of NHS employees wanting to park there.
Okay. I'm just going to move on now to the next bullet point, develop beyond the southern boundary wall, and the appellant's team. Do you accept the criticisms? I think you've referred to it in previous sessions about development beyond the southern boundary wall.
Sir, I think we accept that development should be drawn back from that location, and again we're confident that the quantum of development proposed can be accommodated within the existing southern boundary wall.
And again, is this something that we can just rely to be addressed in matters specified by conditions application, or should we actually specify no development in the planning permission stage?
Yeah, certainly, sir. From our perspective, we wouldn't have any issue with that explicit reference in a planning condition. I think I've termed the area of land in my hearing statement as being the western flank, just to avoid any ambiguity in that respect.
And that deals with beyond the southern boundary wall, but as we saw on site, there's also a belt of trees there, and the levels drop quite sharply down to the car parking area for the hospital and also the hospital buildings. Are there any other restrictions in that area that we need to make clear in the planning permission in principle?
Certainly, sir. From our perspective, not probably in principle. I think certainly the reference to drawing in from the southern boundary wall would be sufficient to protect that zone of the site. And then it would be for us to demonstrate in any details that are submitted to the council that the topography of the site can be respected. Make the point, sir, that we obviously note in the hearing statements that the development of the 70 units at the site is considered to be achievable in a number of different ways across the site. There is flexibility to accommodate the number of units proposed across the site, and I think I refer to varying plot sizes and building types, which may ultimately come forward. And equally, if any developers involved, they may have a different approach to how the delivery of units might be taken forward at the site.
Yes, I know you aspire to 70, but 70 isn't actually the thing before me. It's just the principle of residential development. Council, any thoughts or comments on that?
Yes, I would certainly agree. I think we would require a condition to be imposed on breaking through the southern boundary wall because, well, for a number of reasons. A, it's part of the listed building because it's the cartilage of a listed building, so it is listed by its cartilage. Beyond that is an area of open space defined in the LDP. So quite pleased that the appellant is not seeking to go through that area, but I think a condition because of its listing and the open space would be required. There's obviously a mature tree belt there, so I think the definable area that could be built on just get that a little bit smaller. And whilst it's mentioned further on in the agenda, there is the potential for noise from the new hospital to have an impact on the design and layout in that particular corner. But I think that the developable area will get smaller. How small or large, that is for a future debate.
Okay. Anyone want to come back on any of that?
I don't think so, sir, from our perspective.
Community Council, any thoughts on this?
We're supportive of that planning condition.
Okay, any other impacts on the setting of listed buildings that we need to discuss? Have we done? Okay, so if we can now move to item 3, assessment of the impact on trees. And the first bullet point, direct impacts. If I can start with the appellant. Would you agree that the mature woodland and trees are an important part of the setting of the listed building?
Certainly, sir, we would agree with you in that respect.
And would you therefore accept the premise that direct impacts on trees should be minimised?
I think that's exactly our position. I think the existing landscape framework across the site is obviously extremely important. Within that, there are some particular tree protection orders, but generally, the mature trees in the setting of the site is very important. That said, clearly the tree survey submitted in support of the application does suggest that the area is in need of some fairly significant management and maintenance to ensure the future success of the areas of woodland.
So, direct impacts minimised or avoided altogether?
I think certainly from our perspective, direct impacts would be minimised and managed as much as possible.
Council, any thoughts or comments on that?
From a council perspective, you would like to see mature trees, and particularly the ones with tree preservation orders, that any impact on them could be avoided. But failing on that, we're certainly looking for it to be minimised. There may be some occasions where driveways may cut across, or potentially cut across in protection areas, and may have an impact on the tree. So we'd be looking to minimise the impact of any future development at that location. But certainly the preference would be to try and avoid the ones with the tree preservation orders in particular.
And just these are all interrelated, obviously, but I'll just move on to indirect impacts. If I can start with the council. Occasions such as this, I'm often told that indirect impacts are often as important as direct ones, and people refer to me about things like changes in levels around the routes, the line of services, overshadowing of houses, closeness of houses. Are all those issues that need to be considered in your view?
I do think they need to be considered. That will certainly play a part in any finalised layout. One of the issues that we come across with other sites where there are existing trees is the impact they will have on garden grounds of people's properties in terms of overhanging, protection measures, and such like, and it becomes a maintenance burden for that particular homeowner. That's something we would like to see avoided on this particular site.
So I take it from that you're saying that is a design consideration to be avoided. What's the best way of ensuring that's avoided when you're faced with a planning permission in principle for residential development? Do you just wait for the details to come in, or should there be some areas that you can exclude?
There is potentially areas that could be excluded, but I think it should be taken into the design consideration. There are some, as we discussed, some direct impacts, and tree preservation orders are the ones that would be the most important. But there are some trees that will have an indirect impact by a future development. I think that's something that needs to be designed in or out.
For the appellant, any thoughts or comments on that?
Sir, certainly from our perspective, I think we would agree with the council in that respect. We've obviously identified potential zones for development across the site. Much of the tree interest is, I suppose, along the boundaries of those sites. But we would expect, obviously, in coming forward, detailed proposals would look into the matter of tree protection in some detail. The tree survey that was submitted in support of the application does include some references to tree protection zones and the importance of obviously updating the work as a detailed design potentially comes forward.
So, I mean, I appreciate you're saying this is an indicative plan, but that indicative plan shows that you're utilising the existing tree avenue in what you call Zone A, which is perfectly understandable. But just in terms of the mechanics of doing that, if you had to build a new road to adoptable standards, possibly put services in, put driveways to roads coming off, to houses coming off that avenue, there is I noticed on site there's a slope between them. Is it realistic that tree avenue can be retained?
Certainly, sir, we're confident that can be the case, and I think there are conditions suggested already by ourselves and the council that would allow for the detail of layouts and site layouts to obviously come forward at the matter specified in condition stage, should that be appropriate. And ultimately, within that, there would have to be evidence to demonstrate that that could be ably accommodated within the certain restrictions that there are across the site, including trees and topography. just being reminded as well that obviously any construction phase is quite important in terms of tree protection. Again, there's references in that respect in the tree survey, and again, there's references, I think, in the suggested planning conditions as to how we might deal with that in going forward.
Council, any comments on that?
In relation to the tree-lined avenue, what we would be looking at as an authority is how driveways can be formed in the gaps in between the trees, and how that affects root protection areas. That is something that we would have to have a look at in greater detail.
Community Council, any thoughts on this? Let's just moving on to the next bullet point. I've entitled ownership. If I could start with the council, is there any requirement to specify that the important trees are in public areas rather than in people's gardens?
Certainly our preference would be that the important trees are kept out with people's private garden grounds, because what can actually happen to them is residents can start think they can do what they want to a tree. A tree as a tree preservation order, you're not entitled to do any work to it without actually having been granted consent to do that, but you know, a layman won't be aware of this restriction.
Appellants, any thoughts on that?
Yeah, certainly, sir. We were just having a conversation about how the site, in some respects, and the majority of the tree belt do lend themselves to being sort of managed separately. I think the expectation would be that the existing landscape infrastructure would be managed as part of a factoring arrangement across the site, and there would be reference in deeds of conditions to future maintenance and management of those areas. And I think that would cover any instances whereby there were particular trees relating to particular properties.
Do you agree with the council that, you know, as a general principle, it's best to avoid trees in private ownership?
Yeah, certainly we would agree in that respect. I'm aware of some other developments, particularly in the central belt, where you have new residential properties within fairly mature landscape boundaries, and they're dealt with in very similar fashions. And I think what the illustrative layout has sought to demonstrate in some circumstances is that there would be obviously a standoff from some of the principal boundaries of the site, beyond which you would then have the private gardens. But obviously it is an illustrative plan at this stage, but that's certainly something that we would have regard to in going forward.
Okay, thank you. Community Council, any thoughts on that?
I don't think we have anything to add at this stage.
Okay, next bullet point, long-term management, if I can start with the council. Should long-term management arrangements be something that we need to consider at the planning permission in principle stage?
I'm not sure if it's fully required at the in-principle stage. It is something very much at the detailed stage, if there's a Section 75 legal agreement required for further matters, that the maintenance of open space and indeed a play area
Clients, any thoughts on that?
Sir, certainly again very much in line with the council. Just to say that it may be that we deal with, by way of a planning condition, the provision of a factoring arrangement at this stage, with the detail of that to come forward with any future matters specified in condition once we know the detail of the proposals across the site.
I have to say, on these occasions, I've heard mixed views about factoring arrangements. Have you actually done any analysis to know the kind of annual maintenance cost that you would be placing on the new residents, to know whether that's realistic at all?
I think certainly, sir, from our perspective, the appellants do have some very recent history and experience of similar types of development, in particular the development of Dingleton Hospital down in Melrose, whereby a similar arrangement exists for equally extensive grounds.
The things that have been told to me over the years is that it's easy to commit to factoring, but when you actually look at the annual cost and you then pass that on to residents, and they balk at that, sometimes the factoring arrangements can collapse. Sometimes there's issues that who is the client for the factor, who is the factor responsible, and whether they have an interest in keeping the grounds as they are. Have you thought through all these things?
Certainly, sir, from the appellant's perspective, the expectation would be that the main hospital building, in any event, would retain or be retained under a similar type of factoring arrangement, which would then conceivably relate to the broader site.
Council, any thoughts or comments on that?
I don't know if it helps give it some context. If the council were asked to adopt the open space area, what our current charge is £370 a dwelling. That usually covers you for the first 10 years of the site, once the site is actually delivered and handed over to the council. After that 10-year period, then your council tax payments kick in to pay for the maintenance of any open space. If you're looking at a private factoring arrangement, there is an element of risk that the company appointed to look after the maintenance could go out of business, or or there may be problems. The council certainly have experienced significant issues with one company in particular over the years, and that's fallen then back on the council to look at maintaining the area of open space. That is something we would clearly wish to avoid, and the private factoring is an avenue that can be looked at, but there is always going to be an element of some risk there.
Community Council, any thoughts on this subject?
I'm not sure we have any particular informative thoughts to add to the conversation, except we're perhaps not quite clear of the definition of long-term maintenance, what that does or doesn't include, what it should or shouldn't include. And secondly, what the enforcement measures are, and it's been alluded to in terms of perhaps people defaulting with their contributions and so on. What effective measures can be taken in the event that that money is not forthcoming, or that the long-term maintenance is not being fulfilled properly?
I'll give the appellant a chance to come back on any of that, and then we can move on. Anything you want to say to wind that up?
So certainly from our perspective, our experience, or the experience of the appellant, is that this kind of arrangement does work. Made reference to obviously the site in Melrose. There's examples down south as well, and I'm aware of some in the central belt. On the point of arrears, certainly the appellant's experience is that those arrears then would be attributed to a particular property, which in the event that they were looking to sell that property, those costs would be the first to have to come back to the factoring company to be able to deal with the loss of payments. But certainly we're confident that an arrangement can be agreed in that respect.
Okay, are we done on impacts on trees? So we move now on to item 4, other design constraints. The bullet points are just taken from the various hearing statements, so let's just run through those in turn. So if I can start with the council. Is there a need for a particular condition to specify building heights, do you think?
I don't believe there is one at this stage. Most developments by, for example, a volume house builder, because their house types will be 2-storey, there may be, on occasion, a requirement for a lower building, and we're seeing more examples now of bungalows being proposed by some builders to deal with certain aspects. In terms of this overall site, potentially look at a mixture of building heights. It depends on the impact it would actually have.
My recollection is it was something from your hearing statement, and it seemed to be a concern that if buildings were too high, that might have an impact on the listed building. But are you comfortable that you could control those kind of details through an application for matters specified in conditions application?
I think the primary thing we're looking at is protection of the view from the main entrance. So you have that distance parameter. There may be an instance in Zone C where a slightly lower building may be more acceptable. But that is something I think we could look at the detailed design stage.
Alex, any thoughts or comments?
Just to agree with the council in that respect, sir.
Okay, next bullet point. I think again it was the council that mentioned you had concerns about back gardens facing onto Mill Hall Road. Is that something that should be prevented by a condition at the planning permission in principle stage?
I think that the overall landscaping condition proposed will help dictate that. To provide some context, generally the council, we have a strong preference that when we have buildings that are getting close to a main road, that there isn't a back garden that's facing out onto the road, and we have the worst potential visual impact of extension sheds, houses, whirligigs, and such like. So the first thing you do see, apart from the A-listed building in this location, will be the actual, as you're travelling along Muir Road, will actually be the frontages of houses, which is the more attractive side.
I can understand that point. If so, why not have a condition at the planning permission in principle stage saying that that's a design constraint?
We could look at that. We could certainly add it into the condition 4 of the in-principle permission, where there is a long list of parameters and work to be done.
Helen, any thoughts or comments?
Certainly, sir, from my perspective, I think we would be confident that matters could be dealt with by way of a planning condition for that issue to be addressed at the matter specified in condition stage, but happy to have a conversation with the council about an alternative. I think in both respects we feel that that can be accommodated across the development of the site.
Okay. Community Council, any thoughts on this?
I think this is something that we're rather wary of, and agree with the concerns voiced by the local authority. We'd be very happy for this to be a planning condition at this stage rather than for the future planning applications.
Okay. The appellant have, looking at boundary treatments, have you any thoughts at all about boundary treatment at this stage?
Sir, not at this stage. And again, there's conditions drafted with the council that would allow for that to come forward as a matter specified in condition.
Council, agree with that?
Yes, partially. The listed, the wall itself is a boundary, and we've covered that in terms of that condition to seek that being protected. Also, potentially the mature trees along the boundary, but also, as we've just discussed, the back gardens. If there's condition agreed on restricting back gardens facing onto Mural Road, that's also a boundary issue.
Our next one was the core path and linkages. If I could start with the appellant, I see the core path is within the red line. Would it be your intention to link paths, etc., to that core path network as part of the proposal?
Certainly, sir, as you witnessed yourself from the site visit, there are some routes through the site, including behind the fire-damaged Gilgo building that connect directly into the core path, and then to the north down by the new hospital site. And I think certainly the expectation would be that those would all be retained.
Council, any thoughts on that?
We would agree with that. We would be very, very keen to see core paths and connections from this particular development to be connected into it and maintained. As I understand that some of the core path is under the appellant's ownership as well, so there is a maintenance responsibility there for them.
And is that something that needs to be conditioned at this stage, or is that another matter that can be resolved by further detail?
I think we have a condition proposed already in terms of no adverse impact on core paths, both during and construction and post-construction.
Community Council, any thoughts on that?
question on responsibility for maintenance of the core path that comes up.
Yeah, and your question would be?
Who's responsible?
It would be whoever was the owner at the time.
The core path does run through the property of the appellant, and obviously people have access to it. The question would be who is responsible for maintaining that piece of the path. We have had issues with that piece of the path in the past with trees falling and not being removed. So my question would be who would we, as a community council, be asking to look after some of these matters?
Appellants, what's your understanding?
So I think we would agree with the point that it's the landowner who has responsibility. The council, I think, have an ability or right of recourse, given that it is part of the core path network.
Okay. Noise. Council, I think the environmental health officer issued that there was the potential for noise from the hospital to influence design and layout. Is that something that needs to be controlled by condition?
I believe we have that covered through the further noise condition, which will dictate what will be an acceptable area to build, and also the orientation and elevations of particular houses, and what effect they would actually have in terms of their day and nighttime readings.
Yeah, that, from memory, that asks for the appellant to put in a noise survey, which should then inform the layout. Could you also do it by actually having a performance specification that every house must achieve a certain noise level?
It certainly has been standard to use a particular decibel level for houses, and that their development has to achieve that target.
Appellants, any thoughts on that?
Certainly, sir. I think the discussions we've been having with the council thus far on conditions would sort of allow for that level of detail to be included in a submission once the detail of the development comes forward.
I was going to address this later on, but since we've raised it, is there much utility in a planning permission in principle for residential development if in effect all you're doing is postponing the discussions that you're going to have, which would define the amount of development? Is there any purpose? If you're saying I'll have residential development, I'm not going to tell you how many houses, I shall put in a noise survey to work out whether I meet are you just postponing any discussion, and are you not going to fall out at the matter specified in condition stage where all these constraints suddenly come and hit you?
So perhaps I can answer that. The answer, I think, is no, in the sense that, and the reason that it's been split in this case is that the development would start with the refurbishment of the hospital, unless the developer has the guarantee that some form of development in principle is accepted on the surrounding land. They would not go ahead with the hospital work, and that comes back to the interrelationship between the two. further, there's a significant cost in getting the amount of design work and detailed work to the standard that the council would require before they would approve details. And in the real world, in terms of which the developer operates, and there is a significant importance in having that agreement in principle at the outset. The developer will run the risk that the council will be able to say, no, you can't have up to 70 houses, you can only, or 70 units, you can only have up to 50 units, or that the split of the units, or that the units provided may be smaller than the developer may have otherwise wished for. But that's the risk the developer's taking at that stage. The risk is not with the council, because the developer cannot proceed until the council has agreed. So whilst the ethos, in my understanding, behind a planning permission in principle, moving aside from this particular developer, which considerations I've been addressing up until now, is to provide that confidence that it is worth going ahead spending the money. And that there's a significant input, even at this stage, in providing an environmental statement, but providing the level of detail to provide the detailed drawings will require significant further financial input. And there's a real scope for it at this stage. And I think Mr. Littlejohn's already referred to the developer's experience of doing this in the borders, which I think Mr. Cullen has some experience of, because I think he may have worked there beforehand. This is an acceptable approach to both parts, because it allows the works to proceed with the hospital with a minimum of delay, and then allows time for the parties, hopefully, to reach agreement on the other matters. And there may be some cases where there are real issues of principle that have already emerged between the parties. But as I understand this case, there are no such issues of principle. There may well be areas of dispute around the detail, and there undoubtedly will be, because it's the nature of the things that the developer will want more and the council may want less. It's unlikely to be the other way around. But the leaving aside transport, the approach of both parties in this case has been constructive, and there's no reason to fear Armageddon at stage 2, if I can overstate it in that colourful language. So a small point. The other point is that input at this case helps define the brief, which again sets the parameters so that we've set our stall out as to what we think the site can contain, but so the council would be probably on strong ground to counter any suggestion that it should be a significantly greater number of units, for instance.
Okay. Council, any thoughts or comments on that?
I would by and large agree with that. The developable area will be defined by further noise assessment, the standoff from mature trees, from the boundary wall, and the existing landscaping that is there. So the principle of development on the site has never been an issue. It is how it is actually delivered and what it will actually look like, what can be contained within the site that's actually that would be acceptable in terms of visual and impact.
And have you any concerns that if the planning in principle is granted without these constraints being explicitly addressed, that when it comes to matters specified in condition stage, the argument could be made to you that, well, if it was that important, why didn't you set it out in conditions?
Well, I believe we have set out some of the constraints in terms of further work that will need to be done at condition 4 of the in-principle application. where it says things like updated tree survey needs to be done, contaminated land assessment, further landscape work. That'll all define the area that can actually be developed to an acceptable and appropriate level.
What your conditions ask for more information. Doesn't actually say, for example, you have to achieve a particular decibel level in a house.
No, that is maybe something we could define more fully. Condition 4 sets out a list. There are further conditions within the proposed list, which gives more detail on what is required to be submitted. I would agree there are some conditions there. Some more meat could be added to them in terms of defining what actually will be required. I'm quite happy to have dialogue with the appellant on those.
Okay, anything more on noise?
There is guidance on noise matters, and no doubt that can be referred to in the conditions, but whether that would be necessary or not is another issue, because it would be those guidance and those standards which would be applied in any event. I think, as I understand it, I haven't been involved in the detailed discussion, but will be apparent tomorrow. The conditions on the Plan Commission in principle are overall fairly detailed. To some extent is very detailed, so the scope for real dispute in terms of principle is limited.
Okay. Contaminated land for the council. How is that going to dictate design and layout?
We have a recommended condition based from our land quality officer who works in our environmental health department, that there may be some contamination on the site from the former use as a hospital, and there is some infill ground. So there will be a requirement for a survey work to be done to identify what that land is and exactly where and how it can be mitigated. Certainly my experience of other contaminated land sites is that they can be mitigated. It's really at what cost.
Parents, any thoughts on land contamination?
Just to support what the council have said in relation to contaminated land, we've had a conversation about the use of planning conditions to be able to control detail submitted at a future stage in the process.
Any other points on other design constraints? Are we done? So can we turn to item 5? And I mean, this is a theme that I've mentioned a few times so far, so perhaps we don't need to go into this in any detail. But for the first bullet point, for the council, in your hearing statement, you do say that the developable area will be more restricted than shown on the indicative plan. Should the developable area be defined spatially at this stage, either by actually defining the developable area or by defining explicit exclusion zones? Or is it your view that all this is best dealt with by looking at the detail later on?
I think, sir, it's a combination of both. I think some aspects will, in terms of developed area, will be defined by some further studies, but there are some exclusion areas in terms of the boundary wall, which is covered by will have, and that should be defined, and also the potential exclusion area around the main entrance to give the listed front elevation some protection.
Parents, any thoughts or comments on that?
I was just going to add that I think we have very much a degree of comfort from the planning application process that we've been through and the environmental impact assessment that was undertaken to begin to look at the developable area across the site in a bit more detail. But I would completely agree that there are aspects whereby we need further detail to be able to more closely define any further exclusion areas and indeed the developable area across the site.
Okay, any other points we need to discuss in relation to conditions that we haven't touched upon? Done? Community Council? Council? Okay, is there any other points that we should discuss at this hearing session? Looking round? Is that it? Right, on that basis then I'll close the hearing session. Thank you very much for that. And we're due to meet again tomorrow where we'll start the conditions session. I'm quietly confident that we're going to finish by dinner time. And I'm just wondering whether if that means, like me, you're going to have to make alternative arrangements with the hotel, whether we can afford to have a bit of a lie-in tomorrow and start at 10. Would the parties be happy with that? 10 o'clock start? Just okay, well, that's as good a reason as any. Right, so we'll meet again here tomorrow at 10 o'clock, and we'll have the final session on planning obligations and conditions. Thank you very much.